Hey, Mr. Kuzmarek.
Good morning. Can you hear me okay?
Good morning. I can. What case are you here on?
Sun Home Services versus Aaron Green.
Okay. Miss Patway, are you here for Elizabeth Smith? You're muted. Thank you.
Mhm.
You're here for Elizabeth Smith for Midland Credit? Okay,
Yeah, that's correct. The defendant is Dawn Davis.
thank you.
Mhm.
If Mr. Green is present, could we be placed in a breakout room?
Yep, he is. I'll bring him in. Mr. Aaron Green?
Yes, ma'am.
Yep, I'll put him in.
Thank you so much.
That's why I'm. Mr. Conti, do you and Mr. Ivanchik need a breakout room, or are you guys set to see the judge?
I think we're set to see the judge.
Yeah, I
Okay.
believe so.
Okay, it'll just be a few minutes.
Thank you.
Good morning, fellas. How about your appearances on Lake Shores versus Zeba?
Good morning, Your Honor. Guy Conti on behalf of Lakeshore Apartments.
John Ivanchik on behalf of Mahat Seba, Your Honor.
Good morning, fellas. Where are we at?
Your Honor, we have two motions pending today. One motion by Mr. Ivanchik is to construe their counteroffer on the offer of judgment as an acceptance. And the second motion is our motion for summary disposition based upon latches for their counterclaim, Your Honor. And my suggestion would be that we handle Mr. Ivanchek's motion first, because if it results in his favor, then the case is over.
I would agree with that, Your Honor.
Okay, all right, so I'm confused.
Okay.
You're asking me to tell you what your offers mean.
No, Your Honor, what I'm asking the court to do is to construe whether or not Mr. Conti's offer and my counter offer are the same thing. Because if they're both
Which
the
is
same.
exactly what I just said.
Okay, all right. Yeah.
It's your offer. If you can't clarify your offer to the other side, how am I going to do that?
Well, no, Your Honor, that Mr. Conti's offer to me and my counter offer were effectively the same thing. That maybe we're saying the same thing, I'm not sure, but that's what the issue is, that Mr. Conti doesn't believe that my counter offer was the same as his offer, and that's pretty much it. That's all it comes down to.
And what authority do I have to tell either one of you what the paper you put on, what the wording you put on paper, what it means?
It's a counter offer, which is more or less it's an offer and an offer of judgment, which is a contract, Your Honor. And more or less, the court would be interpreting the terms of a contract.
But it's not a contract if you both haven't signed it.
The way that the offer of judgment works, I guess.
Counsel, hold on a minute. Don't try to school me.
Okay.
All right. I was doing offers of judgment a long time ago. I understand what an offer of judgment is. What I'm asking you is, what is my authority to explain the language that you two created?
I don't know that you have it, Your Honor. I guess, I don't know.
Yeah, and that's, I've only been in this business for 3 decades. I've never even seen a motion like this or heard of one.
Okay. Well, Your Honor,
So
I was
my thought is, if you don't know what the other offer is, don't accept it.
Okay. I guess then that's what the answer is here, Your Honor. Okay. In which case, but we didn't accept his offer. We offered a counter. He didn't accept it, and that's where we're at.
Then let's go to trial.
Well, I believe Mr. Conti has a motion for summary disposition.
Well, then let's go to motion then.
Okay.
But, and once again, if either one of you think I have some authority to do something with this motion that I've never seen one like it, then share your argument with me, because I've never seen such a thing.
Your Honor, I have filed one in the federal court before, because there was an issue with the offer of judgment that the defendant had given to the plaintiff. And we asked the court for assistance to clarify the terms. And I guess my thinking was that we tried to do the same thing here, but I understand where the court's coming from here.
Yeah, but I'm gonna guess that case was at a different procedural point.
It was at the beginning versus where we're at, which is hopefully towards the end.
Your Honor, if I may, I do believe this court has the authority to decide whether or not Mr. Ivanchek's counteroffer was an acceptance under MCR 2.405C1. But I think that's as far as it goes, because I think that court rule is actually very clear, which is, an acceptance is just an acceptance. You can't add or subtract conditions to the acceptance. And to that extent, I think the court has authority to decide whether the counteroffer, so to speak, was a precise acceptance of the offer. I think that, and I think that it's clear that it wasn't. It was yes, the same amount of money, but Mr. Ivanchek added certain conditions to it on the applicability of the judgment in external, in proceedings external to this one, and so.
Right.
So I do think you have the authority to say, look, the counteroffer does not meet the requirements of the acceptance, but and I'm only answering the court's question because I wanted to elucidate. So
yeah, I appreciate it. Yeah, I appreciate it, and I would agree with that, Mr. Ivanchek. I think you would too.
Yeah, I mean,
from that standpoint, I guess we can go back to law school, contracts 101. If there's an offer made and the acceptance changes or adds conditions, that's really not an acceptance.
Right. Yeah. I think the mirror image rule, I think, is what we're thinking of here, that the offer, if the acceptance doesn't mirror the offer, then it's a rejection. But if the if the offer and the counter offer are the same, then it would be treated as an acceptance. That's probably the easiest way to, I think, distill it down. And
okay.
I mean,
right.
Obviously, Mr. Conti disagrees. I I would say that, and maybe it would be helpful if we just kind of read through what the offer was versus the, I guess, our counter offer, and kind of what the reasoning behind it was. But, and I don't
Go
know.
ahead, I'll play along. Go
Okay,
ahead.
sure. So Mr. Conti's offer, give me a second here, was simply plaintiff/counter defendant by and through its attorney offers entry of judgment to counter defendant/counter plaintiff as follows: judgment in the favor of plaintiff/counter defendant in the amount of $100 as to all claims and counterclaims and inclusive of all attorney's fees and costs. And then our counter offer would be pursuant to MCR 2.405A2, defendant/counter plaintiff by and through her attorneys hereby submits her counter offer for the entry of judgment in plaintiff/counter defendant's favor in the amount of $100 as to all claims alleged in the second amended complaint arising out of the alleged breach of the lease entered into by the named parties on December 23rd, 2013, including all attorney's fees requested by plaintiff/counter defendant. The judgment in plaintiff/counter defendant's favor includes a judgment on all counterclaims asserted by defendant/counter plaintiff on May 11th, 2021, including the request for attorney's fees under the Landlord-Tenant Relationships Act, the State Truth in Lending Act, and the Michigan Consumer Protection Act. So my reading is,
so
yeah.
let me make sure I understand the arguments. So Mr. Vanchek, you're saying that your response was an acceptance of the offer. And Mr. Conti's argument is that it wasn't an acceptance of the offer because it added something or deleted something or changed it in some way, shape, or form.
And one other thing, Your Honor, Mr. Vanchek explicitly made the offer pursuant to MCR 2.405A2, which says counteroffer means a written reply to an offer served within 21 days after service of the offer, in which a party rejects an offer of the adverse party and makes his or her own offer. So by citing the actual court rule that he made the counteroffer, he destroys his argument.
Right, right.
But it's ultimately up to the court.
And I'm not as smart as those federal judges, obviously, but if you wanted to accept the offer, then how about I accept your offer?
I understand, Your Honor. And my concern was, as stated in the motion, was and Mr. Conti alluded to, there was outside litigation between my client and debt collector that's connected to this case, who's not named as a party. And the counsel for that case, which I was not an attorney for, had indicated that what he was fearful of is that accepting the offer as was stated by Mr. Conti would also more or less end the case in the federal court, even though it was between two different parties. I did not concur with that decision. Unfortunately, this is where I'm being put.
Right. Yeah, I don't know how it could.
Well, Your Honor,
let me move you along.
Okay.
Let me move you along. I don't think what you responded with was an acceptance of the settlement offer. So that gets us to the motion for summary D, I think.
Yeah.
Yes, Your Honor.
Okay.
That's Mr. Conti's
Right.
motion.
Your Honor, this is our motion for summary disposition based upon laches, which basically the scenario was we had filed our complaint under account stated as discovery. When discovery ended, Mr. Vanchek filed a motion for summary disposition pursuant to a few different subportions of 2.116C, some of which triggered our right under 2.116 I-5, I believe, to amend. It looked, the discovery indicated to me that it was an inappropriate cause of action to be under account stated. So we asked for permission to amend to breach of contract. Your Honor, in our motion to amend, we pointed out not only the court rule triggering a qualified right to amend based upon Mr. Vanchek's summary disposition motion, but also that we included copies of the discovery requests from the defendant to show that there was no prejudice, that their discovery was was actually discovery that was appropriate for the cause of action that we wish to amend to, which is breach of contract. And this court granted our motion to amend. So we amended and added breach of contract. At that time, Mr. Ivanchek's client answered, but also added a counterclaim, a number of counterclaims that we did answer, but discovery had ended, and so we filed this motion for summary based upon latches. The only thing I would add, Your Honor, to the motion, which I'm sure Your Honor has reviewed, is that MCR 2.110 defines what a pleading is and what the types of pleading are. And what's important to note is that what Mr. Ivanchek's client did was not amend their answer, but in fact added an entirely new pleading, because under MCR 2.110A3, a counterclaim is a separate pleading from an answer, which is defined as a pleading as MCR 2.110A5. So what we have is a situation where we're almost a year into the case. I think we were 9 months into the case, and now we have to either go back to the drawing board and start discovery on the statutory counterclaims, or move forward to trial. And so that's the basis of our motion, Your Honor. We've put all the standards for latches into the motion, so I'm not going to go through that unless Your Honor has questions, and I'll give Mr. Ivanchek an opportunity.
Thank you, Mr. Conti. Go ahead, Mr. Ivanchek.
Yeah, sure, Your Honor. So I don't recall Mr. Conti citing to MCR 2.110 in his motion as to explain the difference between a claim, counterclaim, and so on and so forth. But as the court recalls, this argument is the exact same argument I raised when Mr. Conti asked to amend his complaint in response to my motion for summary disposition back in the spring. I stated right in my response that, hey, if you do this, then I am going to do this. I am going to amend to add a counter complaint, because my client had at that point, as we discovered through discovery, a cause of action, which we did not know about when this case was originally filed. It wasn't identified until after we had done discovery. And at the time that Mr. Conti had filed his request to amend, I pointed out to the court then that discovery is now closed, and we're kind of putting me and my client in a bad situation where we're defending a totally different cause of action from when the case was originally filed. And the court allowed Mr. Conti to amend. There's nothing in MCR 2.116I5, which is the amend as a matter of right in response to a motion under C8 or C10, that limits the ability to file a counter complaint. And MCL 600.5823 it states that so long as this complaint was timely when it was filed, Mr. Conti's complaint was timely when it was filed, any counter complaint that I later raised is timely because it extends the statute of limitations under the law. And quite frankly, Mr. Conti also has provided no authority that says that latches applies to a statutory cause of action, which that is what the plaintiff or my client has asserted here, which are all statutory cause of actions, violations of the security deposit law, truth in renting, and Michigan Consumer Protection Act. Latches is an equitable defense, not a statute of limitations that is an actual statute enacted by the legislature. It is meant to shorten the time or prescribe the time to bring common law causes of action. There's nothing that Mr. Conti has provided that says that it applies to a statutory cause of action. And I believe we cite to the opposite that says, hey, like this is, statutory versus equitable. So I don't really understand what prejudice Mr. Conti has here. He didn't really allude to any in his motion. Discovery has closed, but the issues here are quite simple. Did my client send a notice when she moved out in 2013? Did she send notice of where she was going so that they could send an itemized list of damages? We say yes. I don't know what opposing counsel says. We have an email that says that she sent a forwarding address to an email address still used by the plaintiff for leasing. The next question is, did the plaintiff send out a statutorily required itemized list of damages? The answer turned out to be no, even though the plaintiff in its attachments to the complaint provided documentation that it made it appear as if they had, but during discovery, it turned out they did not. So those are really the only two issues, and we already have answers on them. I don't know what discovery we would need. So I don't see that there's a basis for this motion, Your Honor. I don't see that there's any reason why we should limit my client's counter complaint. Mr. Conti was warned when he filed a motion to amend, when I responded to his motion back in the spring. And he can't be taken by surprise if we said, hey, if you do this, we're going to do this. So I'd ask for the court to dismiss the motion and let's proceed with the case. It's been wasting along for too long.
Mr. Conti, respond.
Yeah, Your Honor, well, I'm not surprised, but we're not claiming surprise. And in terms of whether laches applies to statutory actions, there is no case law that says it doesn't. And we're not talking about a statute of limitations. We're talking about within the case, whether or not what Mr. Ivanchek's client is doing by pleading a counterclaim is equitable. So it doesn't involve statute of limitations. In terms of the fact that these facts were discovered in discovery, I think that's disingenuous, Your Honor. If one reads the counter complaint, there is nothing in there that was not within the plaintiff's knowledge, the counter plaintiff's knowledge at the time the complaint was filed. These have been consistent allegations by the counter plaintiff, if not in pleadings, in position, and that's just not, it's just not so that there is something discovered in discovery that was required to bring these counterclaims. These counterclaims could have been brought at the onset of the case. And I want to point out, Your Honor, the statute of limitations is not the same as laches. Laches, to say that laches doesn't apply to any statutory actions would mean that a litigant could engage in inequitable conduct and not be subject to it. And that takes away the whole idea of a court having intrinsic authority to manage its own docket, to manage its own case, and to manage the conduct of the parties in that case. Thank you, Your Honor.
All right. Anything else, gentlemen? Mr. Vanjak?
The only thing I'd like to point out, Your Honor, is just Exhibit A that's attached to my response. It's the document that was attached to the complaint states that it was the itemized list of damages. It states date mailed to resident 8/18/14. That's all I had when this case was filed. The only thing I had was my client statement that she didn't receive it. And I have a document from the plaintiff attached to the complaint that says that they sent it. And then it turned out in discovery that they had not. So I'm not sure where Mr. Conti is thinking that I was aware of this. I'm not going to file a counter complaint if there's not facts to do that. I'm sure the court knows that once the landlord files that or sends that itemized list of damages, then the remedies afterwards are very different than as if they had not sent the itemized list of damages. And so, I mean, if you're providing a document to the court, to the defendant at the outset that says it was sent, then why am I, what notice do I have that it was not sent? Until in discovery, I simply asked the question, what day did you send it or whether you sent it? And the answer was just that it wasn't sent. So we've got two contradictory pieces of information here.
All right. Thank you, gentlemen. All right, fellas, I never do this, but I'm not going to give you a decision today. I want to take a chance to go back and reread your briefs on the summary disposition motion. The first go around was, I think, back in September when we adjourned this. So I want to take another look at those. I will do that today. And probably because it's easier on me, I'll probably have Heather contact the two of you and just set up a quick Zoom so I can put you on Zoom and give you my decision. Understood? Okay.
Yes, Your Honor.
Thank you.
Thank you, gentlemen.
Thank you, Your Honor.
Enjoy your day.
You too, Your Honor.
Heather, who's ready?
Mr. Conti, did we lose Mr. Conti? Because there was another case with his name on it.
I didn't dismiss him, but I think he did.
I think so too. Mr. Green
Well,
and
we'll get
Mr.
him back in.
Okay, we have Sun Homes versus Green. Mr. Kazmarek is for Sun Homes.
Thank you. Good morning, gentlemen. Counsel, your appearance.
Good morning, Your Honor. Joshua Kosmerick, P80941 for the plaintiff, Sun Home Services.
Mr. Green, you can hear me okay?
Yes, Your Honor. Good morning.
Awesome. Good morning. Counsel, what do we have scheduled today?
Your Honor, today we have plaintiff's motion for summary disposition. I did have an opportunity to speak with Mr. Green. We are withdrawing our motion. We have come to terms on an agreement whereby Mr. Green will pay the sum of $480.32 upon receipt of which we will be filing a dismissal with prejudice with the court. So we're all set. We expect that payment, I believe, fairly soon. So we're not competing with any upcoming deadlines. So
Okay. Counsel, why don't we do this? I'll put it on my no progress docket. So in 30 days, if we don't get any official paperwork from one of you, we'll just dismiss it.
perfect. Thank you,
work?
Your Honor. Yes, Your Honor.
Mr. Green, any questions?
No, Your Honor.
Have a great day, gentlemen.
You
Take
too.
care,
Thank
Your
you.
Ms. Petway, Ms. Dawn Davis still has not appeared yet. I just wanted to let you know that.
Okay, thank you.
Judge, I'm going to bring in a couple of these attorneys. I don't know what cases they are here on.
Okay.
Hi, Mr. Cox. Can you tell me what case you're here on, please?
Yeah, good morning. I'm hearing this morning on the Michigan Education Association versus,
So you're here for Miss Winters.
that's correct.
Okay, yep. I have Miss Johnson in the waiting room. I'll bring her in. Attorney McCoy,
Yes, good morning.
good morning. What case are you here on, please?
So I'm here on 214136 GC.
Can you tell me a name?
Yes, so Ford Motor, I'm representing Ford Motor Credit Company versus Tabitha Bananas.
Oh, I see you. Okay, thank you. So you're here for Mr. Zuba.
Correct.
Okay. All right, Judge, I have Michigan Education versus Elizabeth Johnson. They're both in here.
Good morning, folks.
Good
Morning.
Morning.
Mr. Cox, your appearance, please.
May it please the court, Keith Cox, Winters and Associates, on behalf of the plaintiff, P59146.
And what do we have scheduled today, Mr. Cox?
Judge, today's a pretrial conference.
Okay, thank you.
Yep.
Go ahead.
Oh, let's just say plaintiff's claims for unpaid union dues stretching back several years. And the defendant's position is that she opted out timely, and plaintiff's position is they have no record of that. So we're trying to see what we can do about that.
Understood. All right. Ms. Johnson, today's a date and time set for a pretrial. What that means is it's an opportunity for me to get a little information about the file and hopefully put it on the calendar and move it towards a resolution.
Okay.
I did read your answer. Is there any discovery necessary, Mr. Cox?
I don't think so, Judge. You know, typically these cases are pretty much dependent on plaintiff's business records to the extent that maybe 30 days, Judge. I mean, I think Ms. Johnson, trying to think. Yeah, I don't know that we have a written opt-out letter that's going to be produced. Maybe 30 days just to clear that up.
All right. And are you thinking motion at that point or trial?
We might try a motion, Judge. My client gave me 40 pages of invoices relative to their billing efforts over the course of time, which we think would set forth the idea that efforts were made to collect. But I think we'd maybe leave open a window for a motion if it's possible.
All right. So and I'm going to explain all this, Ms. Johnson. I know we talk our own language. Mr. Cox, I'm assuming what you would prefer to do is just adjourn a pretrial for 30 days worth of discovery?
Yeah, Judge, actually, maybe we could kick it maybe more like 45, because if we were going to have a dispositive motion heard, I would suspect we'd want to have it heard at the next court hearing date. And a 30-day window for discovery really wouldn't give us a chance to do discovery and file that dispositive motion.
Right,
And
I'm
given the holiday.
Yeah, I'm just trying to determine what I'm gonna put on the calendar next. Am I gonna make a
Yeah.
note that you're gonna notice up a motion then?
Yeah, Judge, that's our intention. So
Okay, okay.
maybe we do it maybe 60 days, given the holidays. Maybe toward the end of January would be helpful, because then we could do the 30 days discovery and have a 30-day window to also file the dispositive motion.
Okay, all right. So Ms. Johnson, discovery is an exchange of information. So I'm assuming, Mr. Cox, correct me if I misspeak, I'm assuming Mr. Cox will probably send you a list of questions and ask that you answer those questions. He might put a request in there if you have certain documents to provide copies of those documents. It's a two-way street, this exchange of information. So if there's any information you need from the Michigan Education Association, you can make that request to Mr. Cox. You understand that?
Okay.
Okay.
And Mr.
Now, what
Mr.
he's telling
Cox,
me.
Oh, I'm
go
sorry. I
ahead.
was just gonna ask, is he the lawyer for the MEA? I don't, there's so many
Correct.
people in here. I don't know who's who.
Correct. Mr. Cox is representing Michigan Education Association today.
Okay.
Okay. So now Mr. Cox and I have talked about this motion. A motion is, and I don't know why, someday I'm going to figure out why. I don't know why we do this in this business, but a motion is just a fancy way to say request. So he's going to file a request with the court. And the argument he's going to make is going to be that based on the facts that are not in dispute and the law that applies to those facts, they should get a judgment against you for roughly $1,600. If I agree with their argument, then the case is over. I'm going to give them a judgment. If I disagree with that argument, I'll deny that motion, I'll deny that request, and we'll move forward with a trial date at that point. Understood?
Okay.
All right. You'll get a copy of that document that they're going to file with the court, that motion or that request. They'll file it with the court. They'll send a copy to you. You can respond in writing, which I would encourage you to do. And we'll have a hearing date. So whether or not you filed anything in writing, I'll give you a chance to respond orally to their motion. You understand that?
Okay.
All right. Do you have any questions about what we're doing procedurally?
No, I don't think so.
Okay. Mr. Cox, do you want to correct anything I said?
No, Your Honor.
Okay. Anything else we can talk about today? Anything we can accomplish?
Is the court going to send out that date, or does the court have it in mind already?
Judge, I have January
No, I'll let-
18th at 9 a.m. if that's good. Sorry.
That's all right.
That's good for the plaintiff, Your Honor.
And that was January 18th, Heather?
Correct.
What time?
9 a.m.
Okay. All right. So that's going to be the date of the hearing, Ms. Johnson. And this is going to be written discovery, Mr. Cox, written discovery only?
Yes, Judge.
Okay. So my note in the file was written discovery for 30 days. Plaintiff's motion to be scheduled on January 18, 9 a.m. Ms. Johnson, any questions?
Yeah, who, I'm sorry, can I just ask who all the other people are in here? Is this all?
Yeah, I probably got 12 files today, and some of those people are already in my meeting room.
Oh,
Got
these are
nothing to
other.
do with you.
Oh,
Nothing
okay.
to do with you. Yep.
All right.
Yep.
All right. Thank you.
The only people we've gotten involved right now that's on your case is you, Mr. Cox, and me.
Okay. All right.
Okay?
Thank you.
All right. It's just like if you were actually in my courtroom, you'd be seeing a lot of people that you didn't know.
Okay. All right.
All right?
Thank you very
No other
much.
questions?
I
Yeah,
don't think
Judge,
so.
I've got one more question. Ms. Johnson,
Yeah.
would it be okay if I gave you a phone call after this proceeding? Are you at a phone number ending in 2026?
No, that's my parents' phone number.
Judge, are we on YouTube, Judge?
Yes.
We are. Ms. Johnson, do you know how to chat? Use the chat function?
How about this, Ms. Johnson? I don't mind giving my phone number out over YouTube. My phone number's in the Bar Journal. I'm on the record. So can I give you a number to have you call me?
Yeah, like right after this.
Yes, right when we hang up here.
Okay. Kevin.
248-228-8344.
Are all
If you could
court
just, right when we hang up, just give me a call and I'll be happy. We can continue our conversation outside the courtroom, outside the audience of the judge. So I appreciate the time, Judge.
Thank you.
You're welcome. Did you have a question, Ms. Johnson?
Are all court proceedings live on YouTube?
99% of mine are.
Oh, okay. I was just curious. I've never seen that before.
Yeah,
All right.
once in a while I'll close it depending on what's going on, like if I have a child victim on the witness stand or something like that. Other than that, it's just like it was with real court. Anybody can walk in and watch.
Okay.
Have a great day, ma'am.
Thank you. You
Thank you,
too.
Judge. Have a good Thanksgiving, Your Honor.
You as well, Mr. Cox.
Thank you. I know.
Heather?
Judge, we have Mr. Conti. I'm sorry, it's Sack Strupp Towing versus Pim Burrows.
All right, Mr. Conti, your appearance, please.
Good morning again, Your Honor. Guy Conti on behalf of Saxter Towing.
Good morning, Ms. Burrows.
Good morning, Your Honor.
Oh, yeah, we had this scheduled for a date back in September. We had some technical difficulties getting everybody on. All right, so this was on our no progress docket, I believe. So,
Taking a
Mr. Conti, where we at?
Your Honor, 1 second here. Looking at her answer. So I believe that Ms. Burrows is claiming that Saxter Towing should have billed her insurance company. And certainly willing to talk to Ms. Burrows if you want to put us in a breakout room and see if we can't
Sure.
do something about
We
this.
can do that.
Thank
We can
you.
do that. Ms. Burrows, we're going to put you in a private meeting room with Mr. Conti.
Okay.
All right, it looks like we have lots of half things going on here. But we do have Betts and Danielle Strace for Optimum Care and Allstate.
Okay.
Danielle?
Are we ready on Optum Care versus Allstate?
Yes, Your Honor. John Betts for plaintiff.
Good morning, Your Honor. Danielle Strace for Allstate.
Good morning. So last time we talked was in September. I think we bumped this out for discovery, correct?
Yes.
All right. Are we
Yeah.
ready to schedule something?
Your Honor, we filed a motion that was set to be heard today. We still have not received plaintiff's discovery responses.
Well, Your Honor.
What's the motion?
I guess
The
this is
motion
part of
is-
the electronic age. They apparently, somebody named Taylor Trusty sent me over an email on October 4th saying it would expire October 6th. I've never received any interrogatories, but taking it one step further, the last time we were before you, Allstate wanted to depose 2 people. And apparently they did that last week to try to determine whether or not Tyra Moore had a valid claim through assigned claims. And of course, I called defense counsel yesterday, and for whatever reason, they don't respond. So I don't know what their thinking is, but that coverage issue, which is the only one that Allstate ever talked about, should be resolved by now.
Okay, Your Honor,
All right, so
actually,
hold on, let me back up. What's the motion that's been scheduled today?
motion to compel plaintiff's discovery responses. We sent them discovery requests on September 29th, 2021, along with our claim file, privilege log, and they were due in 28 days. So before October 27th, I reached out to plaintiff's counsel on November 8th, 2021. For whatever reason, I did not get a response. I never received a response to the motion, still haven't received a response to discovery requests.
Well,
And
let's take it one step further. I've never even received the discovery matters. I mean, I don't have any trouble providing good faith responses to good faith discovery, but the court has never ordered the parties to permit the parties to exchange discovery by email or electronically. And as I say, I apparently got something from somebody named Taylor Trusty that I didn't even recognize. I mean, I get probably 50 emails a day. A lot of it is junk emails. So when something from Taylor Trusty comes in my mind, it's probably junk.
Your Honor, it was
Okay.
specifically indicated exactly what it was. I sent a follow-up email from myself indicating we still had not received discovery responses. I specifically attached a stipend order to produce those discovery responses. When we were here in September, I discussed the fact that we would need discovery. I sent those within a few days.
Danielle, if you would have returned my call yesterday. we could
Mr.
have
Betts,
resolved
if
this
you
without
interrupt
taking
that
up the
woman one
court's
more time, I'm holding you in contempt. Is that clear? Mr. Betts,
I'm sorry,
if you
Judge.
want to interrupt counsel again, I'll hold you in contempt.
Understood.
Cost of $500. Responses are due within 30 days of a certified mailing of the interrogatories to Mr. Betts. Clear?
Judge, may I make a statement on the record, please?
You can answer my question. Is my order clear?
I understand what ruling you just made.
Now you can make your statement.
Okay. The court has never authorized discovery to be conducted in this case electronically. The court rule provides that an order has to be entered for that to take place. And as I indicate to you, my client isn't trying to shy away from responding to discovery. We did not receive it, at least receive it in any sort of form ordered by the court. And of course, the exhibit to the motion that the defendant filed, it says they sent something, or Taylor Trusty electronically sent something to me on October 4th, which expired on October 6th. So I couldn't even access that that email before yesterday or even today. I don't have access to the discovery request as of this moment.
Your Honor, that's incorrect because
Counsel, I didn't ask you to say anything. I did not ask for a response, Ms. Strays. Mr. Betts, is your statement over?
I didn't catch what you said, Judge.
Were you finished making the statement you wish to make?
Yes.
Then we're done here today.
Your Honor, can I also indicate that we were unable to take the depositions of the claimant. They did not appear for the deposition, so we are filing a motion for alternative service.
File the motion.
Thank you.
Your Honor, is the discovery still open?
Yes.
Understood. Thank you.
Thank you, Judge.
Hey, Heather,
Yes, Judge.
I'm getting some weird report whenever I remove somebody from the meeting about whether or not I want to submit a report about removing somebody. Can you figure out what that's all about with Fred today?
That used to happen to me when I would do it. I think just hit okay or just agree with it, but I will ask him about it.
Thank you. All right, Mr. Conti, back on.
Good morning again, Your Honor. Ms. Burrows and I have reached an agreement. Your Honor, what we're going to do is enter into a consent judgment in the amount of $900. We're going to waive court costs in this particular case. And Ms. Burrows is going to start paying, and this is of course with the court's approval. Ms. Burrows will pay $25 a month starting on January 15th, and she'll do that through June 15th. And I know generally we don't like to keep the cases open, but I'd like to set a review hearing sometime in late June. There's circumstances in this case, I think, that call for that because we'll want to see where Ms. Burrows is at that time. She does have some very unique challenges, which she has told us about in the past, and we don't want to hurt her on this payment plan. But she may have a greater ability in the middle of next year to pay, or she may not, and that's why we want to do that if that's at all possible, Your Honor.
We'll play your game. Ms. Burrows, that fit your agreement?
Yes. Yeah, Your Honor.
Okay. All right. And Mr. Conti, you're going to send us something?
Yes. And I'd ask Ms. Burrows, would you trust me and allow me to send the judgment to the judge without you seeing it first, but you will see it after he signs it. And so if there's any problem with it, you could then let me know and we'll fix it. Is that okay?
Yes, that is.
Okay.
That will expedite things, Ms. Burrows.
Yes.
All right. Good luck, ma'am.
All right.
Thank you, Your Honor. Hey, Your Honor, have a great Thanksgiving. Oh, I'll probably
You
see
as
you
well,
before
Mr.
then,
Conti.
based upon what you said on the previous case. So,
Well, yeah, you probably will.
all right. Thank you.
Okay.
We have second round versus Frazier, Judge, Ivy Frazier.
Second round versus Frazier. That sounds like a boxing thing.
Yeah, it does. Miss Frazier's still connecting. Oh, she's connected.
All right. Counsel, your appearance for second round, please.
Good morning, Your Honor. Adam Berman, P68586, appearing on behalf of the plaintiff.
Good morning, Ms. Frazier. Can you hear me okay?
Good morning.
Good morning. Counsel, I think you're on our no progress docket. So where are things at? Where are things at with this file?
Yes, it appears the parties met in July and agreed to a consent judgment. As of today, we hadn't received the consent judgment back from the defendant. Possibly, maybe I could speak with her in the breakout room.
Sure.
Shortly to discuss that, because she is making payments. We just need the signed paperwork back from her so I can speak with her regarding.
We can do that. Sure, we can do that. Miss Frazier, we're going to put you in a breakout room.
Okay.
Hey, Heather, what happened to Ford Motor Company?
She had sent some message that the other attorney wasn't appearing, that it was going to be dismissed. We chatted, told her to send the paperwork.
Okay, that's Ford Motor versus Banis, right?
Correct, yes.
Thanks.
Yes. I'm going to bring in Miss Ellen Seaborn. She is Midland versus Seaborn. Stephanie Petway is on for Midland.
Got it.
So Miss Petway, you did need to speak to Miss Seaborn in a breakout room?
Yes, that would be great. Sorry, I just saw your message, Heather.
That's fine. I'll put you in.
Thanks.
All right. Zanin and Tiffany Anderson. This is TC October versus Anderson.
Okay.
Good morning.
Good morning, Carrie.
How are you?
Better than I deserve.
Miss Anderson is not connected.
Carrie, when we get Miss Anderson connected, you want a breakout room with her?
I do. This is the dilemma, Judge. I was told she applied for Sarah. That was months and months ago. My client has heard nothing about it. I need to know where we stand, or I need to move forward.
Okay. I think we've got her connected. Miss Anderson, are you connected?
Yes.
Good morning. We're going to put you in a breakout room with the attorney for TC October. Understood?
Okay.
All right. Good luck.
Thank you.
All right, now let's see. I have all these halves and I don't know what to do with them.
Well, let's see.
Do you know?
Midland Credit versus Davis. Is that one of them? Because that's
Davis
default
is
to-
not here, but Midland Credit was Miss Petway, and she's in the breakout room.
All right, we can do a default on that one when she gets back.
Okay. I don't see anybody from Community
Any of our
Finance.
845s. Yeah, Community Financial, Sackstrup we did, Alta Equipment, Wellesley Townhouses, Jefferson Capital. We could default any of those.
Well, I gotta bring all these people in because I don't know who they are.
Yeah, that's all right.
Mr. Kaczynski?
I think Mr. Kaczynski's on Wellesley.
He is, I just don't know if we're expecting Miss Dominique Johnson.
Well, if we can get him to talk to us, we'll find out.
Miss Nonis, are you here for Michael Beach?
Yeah, I'm from
And-
his firm, for the same
Okay.
firm.
Council, is that on Jefferson Capital?
Yes, for Gibson.
Yes, ma'am. This was scheduled at 8:45 for a pretrial, correct?
Yes, Your Honor.
And I don't see Miss Gibson in our waiting room. Heather, do you? see
No,
her?
I do not
Looks like
either,
everybody's
Judge.
Identified. All right, council, why don't you submit a default judgment under 7-day rule?
Will do.
That all you got today with us?
That's all I have. Thank you. Have a good holiday.
You as well.
Thank you.
Did we lose Mr. Kaczynski?
Miss Butler, are you here for Parkside Credit?
Yes, I am.
Okay. The other party has not appeared yet. I just wanted to verify.
Thank you. I know I'm a few minutes early. If she does arrive, I would like to speak to her before the hearing, if that's possible.
All right.
Thank you.
Mr. Berman, what are you here for?
Appearing again on second round sub versus Ivy Frazier. We were in a breakout room.
That's right. And here's Miss Frazier. Okay, we're back on the record with second round.
Good morning again, Your Honor. Adam Berman, appearing on behalf of the plaintiff.
And where are we at, counsel? Did we get
Your Honor,
paperwork straightened out?
Well, I did resend just now Ms. Frazier a copy of the consent judgment to sign. She indicated she will sign that today or tomorrow and get that back to me, and we'll get it off to the court as soon as possible. So we do have an agreement in place. We're just waiting for the paperwork once again. There was a misunderstanding about signing the paperwork previously. So we should have that court. If you want to set it for another short review hearing, maybe 30 days.
We have December 21st, if that works.
That's fine.
All right, Miss Frazier, you got that?
Yes.
Is that
Yes,
at 9
Questions,
a.m.?
ma'am?
No, I do not.
All right, anything else, counsel?
Was that at 9 a.m. on December 21st?
That's fine, 9 a.m.
Okay. Nothing further. I do have another matter up for 9:30. There is opposing counsel on that case, but nothing further on this case.
Okay, we'll see you in a few minutes then.
Thank you.
Have a good day, Miss Frazier. Miss Petway, are we ready?
We are, Your Honor.
Miss Seaborn, can you hear me?
Yes, I can.
Good morning.
Good morning. How are you?
Excellent. Counsel, what do we have scheduled today?
Your Honor, today is the time and day set for a pretrial, excuse me, The parties have had an opportunity to speak, and if the court has no objection, the parties are requesting a short adjournment of today's pretrial based on the fact that the defendant is currently suffering a financial hardship, and I would like to get her applied for my client's hardship program. But we do need to mail out some documents, wait for those documents to be mailed back to our office, which could take a little bit of time.
Heather, was that a December 31 date?
December 21, Judge.
21. Is that giving you enough time, counsel? You need a little bit more.
I think a little bit more, Your Honor. Just given the
January-
holidays and how slow the mail already is.
January 18th.
That would be fine.
What time you want it, Heather?
9 a.m. is good.
Thank you.
Ladies, that work?
That does work.
Yes, it does.
All right. Have a great day.
Okay, thank you.
Your Honor.
Same here.
Thank you, Ms. Seaborn.
Okay, thank you.
Mr. Kaczynski. Maybe he's busy. I'm bringing in Mr. Greenblatt for Mr. Berman's other case.
Which is?
Synchrony Bank versus Elizabeth Leggs.
Thank you. Gentlemen, your appearances on Synchrony versus Leggs.
Good morning, Your Honor. Adam Berman, P68586, appearing on behalf of the plaintiff.
Good morning. Good morning, Your Honor. Philip A. Greenblatt, my bar number is 54170 on behalf of the defendant Elizabeth Leggs.
Where are we at on this one, fellas?
Your Honor, this is on, nope. Oh, go ahead, Mr. Greenblatt.
Thank you. My apologies. I didn't mean to jump in and interrupt. Judge, if I may, the problem and why you're seeing us here today is that there's been a breakdown in the attorney-client relationship such that I've made certain recommendations to my client that she's declined to accept. And I've indicated to her that based on the breakdown in the communication, that it would be my intention to file with the court a motion to withdraw. She has not signed a stipulation, and it has sort of dragged the process, no fault of brother counsel. I would have hoped we would have had this matter concluded with the proposals that brother counsel and I have discussed. But as such, I was hoping the court would indulge my office with an opportunity to file a motion to withdraw and allow Mr. Berman to proceed in the fashion he deems appropriate to represent his client's interests.
Sure. Heather, that was December 21 or January 18, correct?
Correct, Judge.
You want to pick one, Mr. Greenblatt?
Why don't we go with January 18th? And I don't know if the court would also allow Mr. Berman to be heard on that same date on his motion, or if you want to do it sequentially.
Why don't we get them filed at the same time?
January 18th at what time?
Let's do them at 10 o'clock. Is that going to be summary disposition, Mr. Berman?
Yes, Your Honor.
Your Honor, may I give Mr. Berman in the meantime permission to also send that notice to Ms. Leggs directly, so that way she knows that she has an obligation to respond to that motion. I will not be responding on her behalf.
That would make sense. Yep.
Okay, same
Anything else,
Zoom
fellas?
ID? Same Zoom ID?
Correct. Correct.
Thank you, Judge.
Have a good day, gentlemen.
Thank you, Your Honor.
Judge, this is Sandy.
Yes, Amy.
I have a defendant down here and we don't have a Zoom capability right now. It's being used. Can I send her up to your courtroom?
Who is it?
Who is it? We didn't get a name. Sorry. I'll get that for you.
Send him up.
Okay, thank
Send him
you.
up.
Goodbye, Judge.
Take care, Mr. Greenblatt.
Thank you. Have a nice holiday.
You as well. Good morning, Mr. Kaczynski.
Yeah, I'm here on Wellesley versus Dominique Johnson.
Yeah.
So this was a case
go ahead.
This case had a serious stay and so we hadn't got paid, so we brought it back up on the docket. I talked to management this morning, and they have been in contact with Wayne Metro. Apparently, they sent a check and it got lost. So maybe I could adjourn this for a week or so. I expect payment to be received this week, and we'll probably enter a dismissal.
I'm going to adjourn you out to December 18th.
Okay, that's fine, Judge.
That's our
December
next date.
21st.
December 21st?
21st, I'm sorry. I'm
Yeah.
confusing December and January.
I'm sure we'll have a
Let's call it
dismissal
9
by then.
a.m., council.
That's fine, Judge.
All right. Thank you, Heather.
Thank you.
You're going to have to call the guys and tell them somebody's got to come let that lady in the courtroom because they got everything locked up tight.
Alrighty.
Mr. Kaczynski, that it? Must be, you're gone.
Yep, now we have Miss Anderson and Carrie Zanin.
Yep. All right, council, we're back on the record with TC October. And Miss Anderson, where are we at?
Your Honor, she reapplied for Sarah on November 16th. I do have that new Sarah number. I know that you normally put a stay on this, Judge. However, this stay has been on since probably like June or July. Can we adjourn it for 3 to 4 weeks so that I can see what's going on, so I can keep control of it this time?
Yeah, how about the December 21 date?
That would be fabulous.
Miss Anderson, that work for you?
You said December 21st?
Yes, ma'am.
Yes, that's fine.
Thank you.
At what time?
Good morning, ma'am. 9 a.m., Miss Anderson.
Okay, thank you.
Carrie, you got anything else today?
That's it. Have a great Thanksgiving, Judge.
You as well. Good to see you.
You too. Bye.
Ma'am, what's your name?
Renee Gallup.
Gallup?
Yeah.
Let me find you on my list.
Okay.
Huron Estates versus Gallup. I will bring in Jenny Sheed.
Ma'am, come on up. Just have a seat. Thank you. Good morning, council. Your appearance for Huron Estates, please.
Yes, this is Jenny Scheid with Swiss Stack Levine on behalf of the plaintiff.
Good morning. I have Miss Gallup in my courtroom. Our Zoom councils are already in use on other matters, so we just brought her in the courtroom today. Do you need to have a conversation with her?
I would like to get an update from her on her SARA application.
Okay, you mind doing that while she's in my courtroom so it's live?
Okay.
I don't mind.
Oh, ma'am. Is that okay, counsel?
Yes, Your Honor.
Okay, now, Ms. Gallup, tell me what's going on with your SARA, please.
Okay, my SARA application was denied.
Okay,
Okay, so I went to social services last Thursday, turned in all my paperwork, including what I needed to get help with breath.
that was last Thursday, so that would have been the 19th or 18th, right?
Yeah.
Did you catch all that, counsel?
I caught part of it. It sounded like she said that her SARA application was denied and she was seeking additional assistance through another organization, but I could not hear which organization. Social services.
Yes, ma'am.
Judge, have her come to the podium and see if that is the mic that is
Can you come up here, ma'am?
louder.
The microphone will
Thank
pick
you.
you up better here. We got it, Heather. Thank you.
Thank you.
Counsel, any other questions for Ms. Gallup?
Yes, I'm here.
No
Any
other
other
questions
questions?
at this time, Your Honor.
All right, what's your pleasure?
So, Your Honor, we can adjourn this out possibly for one more week for Ms. Gallup to be able to secure whatever funding or assistance that she's going to be able to get from social services. But other than that, we're going to have to, after that, proceed with the judgment because right now, this is balance is getting larger. It's over almost $4,000 at this point. And this has been ongoing now for several months. So
Right. Right.
We'd still
Okay,
be
well,
in the
it
same
takes
month
a-
if we could
Hold
get
on,
an
ma'am.
adjournment of 1 week.
Okay. Ma'am, did they give you any indication last week how long it'll be before you hear something?
It takes 10 days for social services. And because of the holiday, it might
Right.
take a little bit longer
Right.
now. I don't know.
Council, I think 1 week is probably just wasted effort for everybody. How about if we go out 2 weeks? That gives her 10 days. So let me see
Just
if I
need
can't
to
figure out a way to
recognize
get
that
you in.
her December
The hole's
rent is
getting
going
deeper.
to become due in the meantime.
Understood.
So her
You
numbers are gonna go
understand,
up.
ma'am?
Yes.
Yeah.
And I'm also going to try to go through Sierra again too for a recertified of an application.
Okay. So council, I could get you in
Judge, we have
Tuesday, the
December 8th.
7th.
Oh, I'm sorry.
You got stuff scheduled on the 8th already?
Yeah,
Sure.
that's your
That
leftover
makes sense.
docket.
That makes sense. Council, are you available the afternoon of the 8th?
Yes, Your Honor.
All right, let's call it 1:30. Ma'am, that work for you?
That's fine.
The 8th?
Yep.
Okay. All right, so we'll adjourn it until the 8th. Thanks, Andy. At 1:30. Okay, and ma'am, you can come back here like you did today. Either we'll put you on our computer if it's not being used, or we'll bring you back up in the courtroom.
Okay, all
Okay?
right.
Good luck to you.
All right, thank you.
Council, anything else?
Not on this matter, Your Honor, but I do have 2 other
All right.
cases.
Okay, we'll just leave it where you're at then.
Mr.
Heather, what do you
Jamal,
got?
Mr. Jamal, what case are you here on?
Yes, good morning. I'm here on the matter of Razor Capital and Meriwether.
All right, I'll bring Miss Merriweather in. Did you need to speak to her?
I don't think that would hurt. I think it'd be a good idea.
Okay. Judge, the last couple people in the waiting room, Butler, Hillard, and Butler and Hillard are the next cases. If you want, Parkside versus Hillard. I'll bring them in while I put these two in a breakout room.
That's fine. All right, I got people bouncing all over my screen. We got an attorney for Parkside?
Yes, Your Honor, I'm here.
Good morning. And looking for Miss Hillard then.
I'm here. Good morning.
That's Sadie. Good morning. How are you?
I'm pretty good. How are you?
Excellent. All right,
Thank
so counsel, where are we at on this one?
Your Honor, I believe Miss Hillard, forgive me if I mispronounced the last name, filed a motion to set aside default judgment. This judgment is from 2016.
Oh, yeah. I looked at this yesterday. Yep.
All right. Do you have any questions for me, Your Honor? I asked that the motion be denied, but I'm happy to talk to Miss Hilliard after to see if we can work something out.
Okay. All right. Ms. Hilliard, did you get the response to your motion that was filed by Parkside?
I did a few days ago, yes.
Okay. All right. So I've read everything, but I'm more than happy to listen to the high points if you want to make any oral argument.
Okay, yes, I'm actually uploading now. I got my documentation together. I just uploaded it. I actually have the police report as well as the credit, the investigation from the credit bureau showing that it was deleted as identity theft. And I have a police report that I actually filed a couple years back as well regarding the account. Like I said, this account was identity theft. I've never been a member or done any business with Parkside. I have never been served. Even the address, like I said, that they said that they served me at, I've never lived there. So I'm not sure who, they were dealing with, but this has never been my account. And I have been a victim of identity theft.
Okay, so well, first of all, let me back up.
Yes.
With a motion to set aside a default judgment, there are two questions I look at. Number one,
Yes.
Do you have a good reason why you didn't do what you were supposed to do that led to the default? In this case, didn't answer the lawsuit.
Yes.
Number two, the second question I look at is, do you have a good defense? What's your meritorious defense to the underlying claim? So those are the two questions I look at today.
Okay.
So my question for you is, when did you first know that Parkside was suing you?
I didn't know they were suing me until earlier in the year when my taxes were actually garnished by them. Prior to then, I had no knowledge.
All right, so a 2021 tax
Yes.
return was your first knowledge of this action?
Yes, back around April, I believe.
Okay, all right, so that would be your excuse why you didn't file an answer, correct?
Correct.
Okay, and then your meritorious defense is this wasn't you that borrowed the money.
Exactly. I
just want to make.
Yeah, okay.
I want to make sure I understand your arguments.
Sure.
All right, Ms. Butler?
Your Honor, my client operated on the social security number it was given, operated on the information it was given. We have a valid proof of service for the judgment. I think Ms. Hilliard said she just uploaded a police report, and I'm trying to open it, but I can't seem to. I've not seen this. I talked to my client. I asked if they ever received a police report. They said no. If they ever removed anything from her credit, and they said they haven't. So I don't know how this would have been removed from her credit without my client doing so. If Ms. Hilliard's identity was stolen, I'm very sorry to hear that, but I believe everything's in order in the file to keep this default judgment in place.
Yeah, but she was served. Well, the person that was served at the address that wasn't hers. So how is that good service?
Well, Your Honor, there are biographical details on there. I can't see Ms. Hilliard's height. I don't want to assume her weight, certainly not, but her age looks right, the race looks right. I don't want to say Ms. Hilliard's not being honest, but from what we had personal service and a signature on that acknowledgement of service. This was from June 30th, 2016.
Let me see if I can find that in the file, counsel. Give me just a second.
No problem. Ms. Hilliard, is there any other way for you to upload the police report? I'm having, it says I don't have permission to look at it.
I uploaded it to Zoom where so I don't know any other way to.
Okay, because we have a signature on our acknowledgement of service, and I would assume your signature might be on something that you provided. So
Yeah, and I saw,
prepare.
actually, the documentation that you guys have, with my, with the garnishment request, you can look at that and you'll see my signature. Even the signature that you guys do have on there is not my signature.
Okay, I'll open that up. I'll open up your motion.
Sure.
Ms. Hilliard, are you referring to the paperwork you filed with the court, the motion to set aside? Is that?
Yeah, with my signature? Yeah. Yes, Your Honor.
Thank you.
You're welcome.
I found that. Can you think of anything else that you might have sent us that's got a signature on it?
No, that would be all.
That's okay. It's okay. I'm just
think she
asking if
had-
there's something else I should be looking for.
I think she had an objection to garnishment too. A motion and an objection to garnishment.
She did. Thank you.
Mhm.
Okay. All right, ladies, anything else?
Yes, sorry, just in response to the counsel saying that her client wouldn't have been able to remove it off the credit report. It's not up to the client to remove it. Credit bureaus do their own investigation and they determine if they find that there has been some type of credit, identity theft performed. And if so, then they have the authority to delete it, which is what they did in my case. So it wasn't up to the client to actually remove it. The credit bureau actually did an investigation, which if you look at the document I provided, that you can see that they found that it was identity theft and removed it themselves.
Okay, well, they didn't tell my client, and I would hope that they would have informed the credit union if that were true, so that they could proceed, but my client hasn't received any notice of this being removed for this loan. I don't know why. I would hope the credit bureau would have told the creditor, but we haven't received anything.
Okay. Anything else, ladies?
No, thank you, Your Honor.
That's all, Your Honor.
All right. I'm going to set aside the default judgment. I'm going to schedule this for a pretrial for December 21 at 9 a.m. Counsel, that'll give you some time to get with your client and find out what paperwork they've got. Hopefully, open up these documents that Ms. Hillard's trying to send today.
Sure.
Ms. Hilliard,
should
may
Ms.
I?
Hillard send those? Should Ms. Hillard send those documents to you to an email address?
Yes. May I provide that email address?
Yes, you can. One sec. Let me grab okay. Okay.
It is E Butler. That's spelled E as in elephant, B as in boy, U, T as in toy, L-E-R, at Bro Law, spelled B as in boy, R-O-L-A-W, then P as in Paul, LLC.com. The whole thing is ebutler at brolawpllc.com.
Okay.
All right. Any questions, ladies?
No, thank you.
Thank you, Your Honor.
All right. We'll see you in December. Thank you. Enjoy your day.
Thank you.
You too.
Bye-bye.
And are we ready on Razor versus Merriweather?
Yes, Your Honor.
Yes, Your Honor.
All right. Counsel, your appearance?
Joseph Jamal on behalf of the plaintiff Razor Capital, P71254.
And what are we doing?
We are going to withdraw our request to vacate the conditional dismissal and enter a consent judgment, or sorry, default judgment. We've agreed upon new terms to get the matter resolved, and we hope to have it resolved in the next couple of months here.
All right. So we'll just set it on the no progress docket for documentation.
Yes, please.
Okay. All right. Ms. Merriweather, you have any questions?
Oh, Your Honor.
Good luck, ma'am.
Thank you very much.
Thank you both.
Bye-bye.
Judge, I'm bringing in Mr. Quellen. So it's Huron Estates versus James Quellen.
Thank you. Mr. Quillen, can you hear me? Mr. Quillen, I don't know if you can hear me, but I cannot hear you.
I just chatted him. Hopefully he's reading it.
Mr. Cost, do you folks have a phone number for Mr. Quillen?
I'm sure that we do. Let me look it up here.
Thanks.
Ms. Banzel, are you here for Mr. Grand?
Yes, I am. I'm standing in for Mr. Grand.
Okay, thank you. Just making sure.
You're welcome.
The other party has not showed, just so that you know, not as of yet.
Thank you.
Yes, I have a number here that's 734-309-6334.
309-6334?
That's correct.
All right, let's see if I can get him on the phone. Who's the attorney for Huron today?
Jenny Scheid.
Thank you.
Yes, Your Honor.
Good morning, counsel. Let's see if we can get him on the phone.
Your Honor, is it possible for you to pass for just a few minutes? I'm finishing up in Flushing right now.
Sure.
Thank you.
Are you Mr. Quillen? Yes, Mr. Quillen. All right, Mr. Quillen, I've got you on my video in the courtroom, but I can't get you on my audio, so I've just called you on my speakerphone. Yeah. All right, so just stand by. I'm gonna hang up now. Just stand by. When the attorney for Huron Estates is ready, I'm gonna call you back.
I don't know what to do because they won't let me, I can't hear you either. But I had to call the number to hear you.
Okay, so just, I'm gonna hang up with you now, and I'll call you back in a few minutes when we're ready for you.
And just answer the phone.
Correct.
Oh, okay, sir.
All right.
Miss Banzel is here for Trilogy versus Kersey. It was at 9:15.
And everybody in the waiting room is accounted for.
Correct.
Counsel, what was scheduled for today?
Your Honor, this was our motion for issuance of an order of eviction.
Writ to issue. And it's right in front of me. I'm signing it right now.
Lovely.
Have a lovely day.
Thank you, you as well.
Thanks. Heather, what else you got?
Nothing, Judge. Just waiting on Miss Scheid for Huron Estates. But we can go through Rossonville Woods versus Hall Jackson. That one was dismissed.
Okay.
Rossonville Woods versus Hardy, also dismissed.
Anything else?
I don't think so.
So all these other files I've got here, nobody showed up? Alta, Community Financial, Midland.
Nobody showed up on Alta. Nobody showed up on Community Financial.
Huh.
Yeah, I think those were the only two, right?
I got two cases for Midland Credit and
We're wait,
another
Miss
one for Huron
Petway
Estates
is
versus
here.
Jones.
Yeah, Miss Petway is here for Midland Credit.
All right, Miss Petway.
Yes, Your Honor.
Good morning.
Hi, good morning.
Midway versus Davis, no contact?
No contact, Your Honor.
All right. The schedule for pretrial today?
That's correct.
Not our first one, though.
No, we adjourned last time because we sent her some financial hardship information,
Right.
and she never responded to that financial hardship.
Submit your default judgment.
Thank you, Your Honor.
And as to Midland versus Sampson, also a pretrial, correct?
That one is on the lack of progress, and I think it may not be scheduled until 10:30. Let me double check. Yeah, Your Honor, that one's
Correct.
the lack of progress, and it is scheduled for 10:30.
What happened? You sent her a consent judgment, you never got it back?
That's correct. She never responded.
All
We
right.
sent it twice and she never responded.
All right, I don't have a phone number in the file. If you have a phone number and you can get a hold of her, we'll try to take care of it early.
Yeah, we don't have a phone number. We only have an email address, and we did send a couple of follow-up emails prior to today's hearing. Also, no response.
Okay, thank you.
You're
We'll just keep
welcome.
you holding out then.
Okay, thank you.
So Heather, Alta, nobody showed up?
Correct. Alta versus Mills, nobody showed up. It looks like Ms. Sheet is ready for Mr. Quillen.
All right, counsel, I'm gonna call Mr. Quillen and get him on the phone. He's having trouble getting connected.
Okay. And thank you for your courtesy, sir.
No problem.
Hello?
All right, Mr. Quillen, I've got you back on the phone, speakerphone in my courtroom. I've got Mr. Cost from Huron Estates and the attorney for Huron Estates on my Zoom, understood?
Yes, sir.
Counsel, is this one of those where the Sarah, you're waiting to hear from Sarah?
Yes, Your Honor.
So Mr. Quillen, tell me where you're at. You submitted some paperwork for some rental assistance. What's going on?
Yeah, I called Sarah yesterday and they're waiting to get a social worker, I guess.
I'm sorry, Your Honor. I couldn't hear what he said he was waiting for.
Yesterday.
He talked to Sarah yesterday and they're waiting for a social worker to assign to his matter, it sounds like.
Okay.
Mr. Quillen, when did you first contact Sarah?
That was the 13th of October.
Okay. Have you done anything to make any partial payments or anything like that?
No, I have not. I'm waiting for Sarah told me to wait on them.
Okay,
So that's what I'm trying to do. They said they're waiting on a social worker to be assigned to my stuff.
thank you. Counsel?
Your Honor, we can adjourn this out to give the organization more time to process his application.
We just adjourned to another one of yours, didn't we? What did we
We
adjourn
did.
that for?
12-8 at 1:30.
12-8? You
Yes.
want to do that one, counsel?
That'll work.
That's fine.
All right, Mr. Quillen, I'm going to adjourn this until December 8 at 1:30.
Oh, okay.
You be that squeaky wheel with Sarah until somebody talks to you and gives you some help.
Yeah, I did call her, sir. I promise you. December 3rd, you said?
December 8,
Oh, 8. Okay. At what time? 1:30?
1:30. That's a Wednesday.
Yeah, okay, no problem.
All right?
Yes, sir. Thank you.
Good luck.
Yeah, thanks.
Counsel, I've also got one for Jones, I think, Huron Estates.
Yes, sir.
And everybody in our waiting room is, well, there is nobody in our waiting room. So I guess we're not looking for Jones in the waiting room. And you haven't heard anything?
I have not. Mr. Cost, have you heard anything from Ms. Jones?
We have not.
All right, what's your pleasure?
We would request a default judgment be entered against Ms. Jones for failing to appear at today's hearing.
Send the paperwork in.
Will do, Your Honor.
All right, have a good day, folks.
All right. Thank you, Your Honor. Have a wonderful Thanksgiving.
Don't we have
Did we
another
miss one,
one?
Mr. Cost?
Yeah, I think we have.
You were brought in for Gallup, Mr. Cost. but
Gallup.
Gallup was handled. It's adjourned to December 8th at 1:30.
Oh, okay. I'm sorry.
No problem.
All right. Thank you.
Thank you.
You're welcome.
So Judge, just leave it up because we're waiting for Ms. Petway for the 10:30.
Yep. I've also got Darian Cooley at 1.
Oh, true. Yep. Okay.
Heather, I'm actually going to handle something and then I'll reconnect it right before 10:30.
Okay, that's
No
fine. I'll
problem.
let you in.
Okay, see you guys soon. Thanks.
Yep. Thank you.
Bye-bye.
She certainly is pleasant.
Hi, Miss Petway. I have Miss Sampson here. Did you want to speak to her in a breakout room?
Yes, please. Thank you.
Yeah. Oh, you know what? She's not connected all the way.
Okay.
Let me chat her and let her know. Oh, she's there now. Miss Hall Sampson, I'm going to put you in a breakout room with Miss Petway. Okay?
Yes.
Thank you. Judge will be out in just a second, Miss Petway.
Okay, thank you.
Thank you.
All right, good morning, council on Midland Credit.
Good morning again, Your Honor. I don't know, did Ms. Hall make it out of the break room? Heather, is she still showing in the break room?
I requested to bring her out, but let me close this.
Okay.
You got Miss Hall, I got Miss Sampson, or a file for Sampson.
It's Hall Sampson, Judge.
Ah, okay, that works. Miss Hall Sampson, can you hear me?
Yes, I can.
Good morning. Miss Petway.
Good morning.
Yes, Your Honor. So the parties did have an opportunity to speak, and as I advised the court earlier, this was a case that was adjourned due to the fact the parties reached an agreement. We sent the consent judgment per email as we discussed at the last hearing. Unfortunately, Ms. Hall Sampson had not received those emails. I asked her to check her spam or junk folder and told her what the name that was sent, which is my paralegal's name, and she did locate them. So she does have the consent judgment. She still agrees with the same terms. Your Honor, the parties are requesting permission to just submit it under the 7-day rule. The defendant has no objection to the terms, and I think that'll be easier than us trying to adjourn it out again and resend it. Okay. Okay, great.
Okay, that works. Any questions,
Okay.
Ms. Sampson?
No, thank you so much.
You're welcome
Thank
so
you,
much.
Your
Enjoy
Honor.
your day.
Have a great holiday. Take care, Ms. Hall Sampson.
You as well, counselor.
Okay,
Thank you. I think she dropped off. It sounds like she had a question for me, but I think she dropped off. I'll send her an email.
Thank you.
Thank you, Your Honor.
Hello.
Hello.
Hey, Christine.
Hi.
Dee, how you doing?
I'm doing good. Just give me 1 second. Let me step outside real quick.
Sure.
Hey, Nina. I'm sorry. Just give me 1 second. Hey, Nina. The guy from Avenir is here to drop the cases off. I just need to step outside for 1 second. Sorry. Okay. Good to go.
You good?
Good to go. Good to go.
All right. What's new?
Well, first let me start with I joined the greatest fraternity and I'm now an Omega man, a member of the Omega Psi Phi Fraternity Incorporated.
Cool.
So that's
How do you
pretty much.
do you join a fraternity if you're not in school?
They have graduate chapters. So
okay. Makes sense. Good.
I joined the Sigma Rho Ann Arbor Grant graduate chapter. And yeah, I'm pretty proud of that. It was, something that I wanted to do and I saw it through. I wasn't able to do it in school, so I found another opportunity, another way to get it done, and I was able to do it.
Good deal. Good deal. How come you couldn't do it in school? Do you just because too many things going on, too busy?
Things going on, and I just wasn't really mature enough to, So, like, I was under a scholarship. I had to have a 3.25. So, and then once I started taking like organic chemistry and science classes like that, it was pretty much a wrap for trying to do something like that. I'm like, all my time was I'm in here meeting with the teacher for organic chemistry. He like, oh, your grade is still looking good enough to pass. And I'm looking at the computer screen like, are we looking at the same computer screen? Because if you looking at what I'm looking at, it's over for me. Like, I don't see what you're talking about. But what I forgot was that in organic chemistry, it's kind of like taking AP classes in high school. So if you get a B in organic chemistry, you really got an A. So the whole time I really had, I had a C minus, I had a B minus. But the whole time I'm like, I got a C minus. Like, I'm borderline about to be at a D. Like, I got to pass all of these tests. I got to get A's on everything from here on out to even hope of having a C. And wasn't even realizing, like, no, you actually right on pace. You just got to remember that the grade you have is a grade higher than what it looks like normally. So I was really stressing myself out for no reason. What? It had me. I'm like, I need A's. I'm going to tutoring. I got a tutor. I'm doing study groups with my other classmates. Like, I'm not failing this class. Especially the organic chemistry was really like how people go back and forth, like, maybe I don't want to do this. Organic chemistry was that class for me. I took it the first time and I'm like, maybe I don't want to be a doctor.
Maybe I'll study something else.
maybe it's something else out there for me that's more of a passion for me. Like, let's explore some other avenues here. So I end up taking like a semester and trying to switch to public relations. But I mean, overall, it really was what I wanted to do. So I came back to it and I was like, I just got to figure out how to, what the best thing for me to do is to make sure that I'm successful. And that was getting a tutor, going to study groups.
Let's talk about that though. Because when you just said that at that point in time, you were rethinking your career plans. So that reminds me, the last time we spoke, you talked about it was time to start pursuing that goal again.
Right.
Right? What's new there? Anything?
Right. So I've talked with my friend. She graduated from U of M. So now she's doing her residency at Henry Ford, actually. So she brought me her MCAT books. She went through, and from each chapter, she kind of outlined like the major areas of focus. Because I think the biggest thing when I took the MCAT the first time is that when you don't really know when you haven't seen it before, you're just studying a bunch of information. So it's like, the things I think that I was focusing on and things that I was really like driving home to myself were things that wasn't even on the test. So then I get there and I'm like, I should have been focusing on how to convert stuff in molarity and all of that in terms of chemistry and different things like that. I should have been focusing more on the amino acids and things like that, where I thought that I was, I'm studying, but I'm not really helping myself. So she outlined pretty much everything for me, gave me her books and was like, here's what you need.
All right. So the next step is you're going to prep so you can take the test again.
Right.
Yeah.
Right.
Good.
I'm already back in the books. So that gets the dream back on track. Exactly.
That's pretty cool.
All is not lost. And yeah, so that's why I had emailed when Christine had checked in with me. I'm like, I got a lot of positive things going on right now, and I'm just like really happy. But it's always important to remember that just because don't basically just to remain humble. Like right now I'm up and I'm happy, but life is all about balance and it's all over the place. So don't get too caught up in the hype of right now, just because, not trying to put any bad things in the air or anything like that, but just saying like, if something, because honestly, so with that, some bad has happened. Like my aunt, she has COVID. She's on the ventilator right now. They just started a treatment where they're basically like injecting oxygen in her leg or something like that to try to take some of the work off of her lungs. Because I don't think the ventilator was giving her enough oxygen or something like that. So, that kind of hit me. And then my uncle, he got COVID. Then today, my girlfriend just got into an accident this morning on Southfield Freeway. She was in like a 5-car accident. And I'm like, just gotta take the good and the bad. Don't get too high when everything is good. Don't get too low when things are going bad. So just a
girlfriend's okay though?
Side tangent. Oh yeah, she's fine. Her car isn't totaled, which being in a 5-car accident, I immediately thought like you had this car for maybe almost 2 months, maybe. And it's probably total and all of that, but they were able to turn it back on, so it's not total. And the damage, it's some front end damage, but it really it's fixable basically. So, and I'm pretty sure she's got good enough insurance so that they either probably get her a rental car in the meantime while it's getting fixed and all of that. So if not, I told her, I'm like, my car ain't moving nowhere. So you're more than welcome to use my car.
There you go. Did you understand that info I sent you?
It just sit there. Yes.
Okay. Yeah. I was kind of all over the
Judge,
place with it.
Judge, you say something?
No, I just gonna say, way to find a silver lining and not having a driver's license.
Oh.
Right? Sitting there ready for you. Yeah. Somebody else can use it. Yeah.
It's sitting there, sitting there waiting if you need it. So.
And it's
but
it's kind of cool that you acknowledge how well things are going right now, because it'd be pretty obvious if a stranger just happened to walk into my courtroom right now. Well, not right now, because right now you're listening. But 3 minutes ago when you were talking, your face was all lit up. A stranger would walk in and say, "Man, that guy's having a great day." It's not always been the way it has been when you were on my Zoom. So I was standing here watching you and kind of, my tail was wagging because I'm thinking, damn, Dee's really up today. It's good. It's good to see. And I'm excited about the fact that go ahead.
I just wonder how things were going with the sponsor.
Go ahead.
Is he?
Oh, you're
I don't-
muted, Dee.
Oh,
You
there
got
he
muted
is.
somehow.
Sorry about
Yeah.
that. Sorry about that.
That's all right.
It's going well. We really been like, my biggest focus is that, you know, the first time I kind of went through the steps, I didn't have a sponsor. I was just kind of going through it with the people at AA, and they were just kind of pointing me in the right direction. And I mean, like, semi-sponsoring me, but you know, it wasn't really like the same. So the one thing that I really wanted to focus on was my fourth step, because I'm like, that's like probably the heaviest step to get through. It's basically like, you know, just going through everything that you've done wrong and things like that, and just how you feel about everything, and just acknowledging even things that you might not think were having an impact on other things. And just that's really what I wanted to kind of focus on. So that's really been what we're focusing on, because I felt like I think I just scratched the surface when I was kind of doing it on my own. So I just wanted to sort of dive deeper into it. And then it's relieving to be able to talk about it to somebody that's kind of on the outside looking in. I mean, he knows me and he has experience with this. So it's like, he can offer me his perspective. He can, you know, just kind of keep me level-headed about it. And then, you know, just be honest, like, you know, you messed up here. Like, you know, and just hold me accountable. So I enjoy actually being able to work the steps with a sponsor, opposed to just kind of going to AA, working through it on your own, kind of figuring things out. So that's really just been where we are. I just
Dee,
want
let
to
me
spend
ask
the
you a
time with
question.
that.
Let me ask you a question about the 12 steps.
Okay.
Because, and I mean, I've never even gone to an AA meeting. I've thought about it over the years. I've thought about like trying to go and just be like the anonymous guy at the AA meeting. And I always felt like as much as I want to go just to see what's going on, because so many people in my, as a judge, I make people go to AA meetings, right? But I always felt that almost like being an imposter to be in there. So I've never gone to an AA meeting. I tell you all that to tell you this. I want your assessment, because here's the way I look at it. And I want you to tell me if I'm right or I'm wrong, because you're doing it. It seems to me going to AA meetings and just going to meetings, and like you said, just kind of trying to do it on your own versus doing it with a committed mentor relationship is like AA versus AA light. You know what I mean?
Definitely.
Is that a fair way to say it? I think you can get something out of AA light, but you're not getting the full benefit of the program without the mentor, are you?
Absolutely, because not having a mentor is basically you interpreting the steps and going through things how you want to. So it's like, for your fourth step, like I said, I felt like I just scratched the surface. I felt like I didn't really go deep into it. Had I never gotten a sponsor, my fourth step really would have just been incomplete this whole time, because I did the fourth step, and it's, you know, to me, it's like, all right, I did the fourth step, let me move on. When the fourth step really should be like the longest one.
A good mentor won't let you fool yourself and just kind of go through the motions.
Exactly.
Right, because our human nature is, you know, we kind of gloss over all those things in our life where we really hurt people, but we don't want to admit it. So if I don't admit that I hurt anybody, I don't have any damage to repair, right?
Exactly.
Yeah.
And I don't have to relive these memories. I can sort of keep them pushed back the way I want it, you know, because a lot of it is I mean, speaking for me, I can't really speak for everybody, but speaking for me, a lot of those memories, you know, I kind of wanted to push to the back of my mind. Like, I mean, you know, I'm going through all of this stuff with court. And so, you know, it's always relevant, but I don't have to necessarily think about the specifics of what happened and things like that.
Right.
But once you start working this with a sponsor, it's like, well, okay, well, walk me through this. So it's like, whereas I want to run away from this and mask these things and just forget about them, basically. It's like, well, no, we're gonna talk through this. We're gonna go through, well, what happened? How did it make you feel? How did it make the people around you feel? How did it affect not only how did it affect you, but how did it affect others? Like, it's not, you can't just, like you said, you can't sugarcoat it and just, you can't take the easy way out.
Yeah.
You really got to work.
That's why this conversation, you can't even imagine how helpful that is to me and probably to Christine as well. Because the next time we've got somebody that's just going through the motions, and I don't mean that like they're just putting time in, but they're just doing AA light. They're going to their meetings, they're engaging in their meetings, but they're not going to that next step to get a mentor that can hold them accountable. It really helps for us to be able to say, look, you're not getting what it's possible for you to get out of this process. So this is a very, very helpful, very, very valuable conversation for me.
Mm-hmm. Yeah.
Absolutely.
Yeah. Because really, Christine, people like us, we've never walked the 12-step program. So
Right.
all we can say is, hey, we know people that have changed their life with 12-step program, but it's so much more valuable to be able to say, look, we understand you're going to your AA meetings, you're telling us you're getting something out of it, but if you don't have a mentor, you're really not getting AA.
Right.
Yeah,
because it would be pretty rare for someone to hold themselves accountable. I agree.
Even if they're trying to, human nature won't let us.
Yeah, exactly. Mm-hmm.
Because you don't want to think about those mistakes that you made, and like I said, you want to push it as far away as possible, and like you can work the steps, but you're gonna work it in the way that you interpret it. And I mean, everybody, even sponsors, they interpret things differently. But if you got somebody who's well versed in it, opposed to just trying to do it yourself, when all you know is, okay, I got a big book, I'll read what the big book says the step is, and then I'll do that. But you can't be objective. You can't, exactly.
You can't be objective. Your sponsor can be objective. I liken this to go home tonight, turn the stove on, and put your hand on that hot burner. Your body won't let you. Right? So, how old are you now? You're what, 28?
27.
27. All right. So 27 years. So for some of the stuff you've been putting in the back of your mind and sugarcoating and all that kind of stuff, some of that stuff's 20 years old. Just because you decide to do the 4th step doesn't mean your body's going to let you fully address all of that stuff objectively and clearly. Your psyche is just not going to let you do that.
Mm-hmm.
I mean, I think that's the human nature that we fight when we're trying to clean up our own mess. I put that in air quotes. So yeah, I think this is a huge part of the process, is to have somebody that, number one, has been there. He's walked where you're walking, right? He's got some sobriety. He cares about you as a human being. For him to look at you and say, brother, I know where you're going with this, but you're not going deep enough. No, I think that's huge. And it's really encouraging to me that you're telling me how important it is, because now I know you're not only drinking the Kool-Aid, you're mixing up the new batch every day.
Definitely.
Right? Seriously.
Right.
I mean, you're in with both feet.
No, for real.
Yeah. And you're not in it with both feet because it's part of probation. You're in it with both feet because you realize that's best for Darian.
Mm-hmm.
Yeah, I mean, that's serious tail wagging stuff for me.
Like from the beginning, I've been committed to becoming a better person. So the only way to do that is to fully commit to everything.
Yeah, I'm excited. I can't wait to hang up on you because I want to go give Judge Green a report. No, brother, you don't understand that. People that work in our business, we need stories like yours to keep us coming to work in the morning.
Yep.
These meetings, these aren't just because of sobriety court. There's a lot of selfishness involved in this. Because now I'm all charged up. This gets me through the next couple of weeks of dealing with people that aren't jumping in with both feet and aren't mixing their own Kool-Aid batch. And I got to try to get them to where you're at. Right, Christine?
Yeah. Yeah. Yes. If we don't get these stories once in a while, we would just quit.
Yeah, I mean, it's like on the ground making chicken noises. It's overwhelming. So this is really cool for us to be able to see how well you're doing. And like I said, that you're not doing it because we're making you do it. You're doing it because you see the value. Because we know there's value. That's why we keep making people do it. But until they embrace it, they can't get the value. Yeah, this is pretty cool.
Exactly.
That's pretty exciting for me. So what else you want to talk about?
It's exciting for me. Well, work has been good. I feel like I'm back on a track to, you know, to move forward. But at the same time, like I said last time, I'm not as focused on it just because it's like, it's not my dream and my goal. So, I mean, it's cool, but at the same time, like I know I make enough to support myself and I'm comfortable. So it's like all this extra time that I have, I need to focus that on attaining my goal. So I've been finding a nice medium opposed to how I was kind of dreading work and all of that and just being upset here earlier. It was like, I'm not moving nowhere. I want to make more money. I want to really use my degree, but it's like all of that's going to come in time. So I'm just like, you know, just bide your time here, continue to just make some money, set some money aside, and then basically put my money aside so that I can have the money to take this test. And that's what's going to open the doors for me. Stop trying to kick doors open and just kind of, I mean, of course I'll always be ambitious. So I am going to try to kick some doors open, but at the same time, stop trying to force myself through doors that clearly are pull doors that I'm steady trying to push. So it's like, just kind of slow grinding, not, you know, just focus on what's really important to me and what I really want to attain.
Let me ask you a practical question.
A lot of like life lessons. It's kind of crazy.
Practical question. How the hell are you going to pay for med school? I mean, are there scholarships out there?
That's what I was.
What are your options?
Scholarships and then stipends and grants. So that's what I've been trying to look into.
Okay.
Because I don't really want to overwhelm myself with too much student loan debt.
Oh my God, no.
But
I talked to a man and woman 2 weeks ago now. They've got a daughter and a son. One of them just finished their residency and one of them just started their residency. And they've got $500,000 worth of debt invested in each child. It's unbelievable to me. It's unbelievable. Yeah. Which, you know, that's not bad, you know, if you come out with a specialty where you're making $4 or $5 million a year. But if you're coming out and you're making 400 grand, 500 grand a year and you owe $500,000, that's a lot of debt. I mean, that's a good salary, but that's a lot of friggin' debt.
Definitely.
Yeah.
That's why I've been trying to look more for
I'm glad you're pursuing those options.
Yeah. So I'm like, I know that's really going to be an expense, but I mean, well, I just look at it as in the end, it'll all be worth it.
Sure.
It's not going to last
What about
forever.
the military, D? Have you thought about the military? And the reason I ask that is I got a buddy of mine whose son is a Green Beret. And I spent time with the guy 2 weeks ago, and he said that his son's commanding officers have told him that they want him to be a surgeon. They want to train him to be a surgeon for the Army. So they want, and they know he's only 3 years into it, right? He just barely got through all his training. He's just been a Green Beret for like 6 months, I think. So his commanding officer said, look, we know you're not going to give up the Green Beret stuff now, but we want you thinking about the fact that, you know, 3, 4, 6 years down the road, we want you on that path. You know, you got to do the kicking indoors and jumping out of plane stuff for a while, because that's what you wanted to do. But at some point, we want to train you to be a surgeon. And that to me, because he's not going to borrow money if they train him.
So one of my fraternity brothers, he's in the military, and he actually mentioned that to me. He was like, you know, 'cause they're pretty much gonna pay for you to go to school, and you can reach your goal a different way without having to worry about being in all these thousands of dollars of debt and all of that.
Right.
And I had never really considered it, but I mean, now that's two people mentioning it to me. So now, it's just kind of got my ears up a
Here's what
little bit.
here's what I want to caution you about though. Your age is against you. For example, if you were 30, I don't think you even got an option. And I know a friend of mine that I went to Michigan State with went to law school probably, I bet it was close to 10 years after we got out of college. Yeah, it was close to 10 years because he joined at 27 and at 28, they wouldn't have taken him. And they put him through law school and he was, worked for the JAG. So there's an age limit there where they won't take you in anymore. So look into it quick.
Okay.
And in our world, in our area, all the recruiters are over on Ford Road in Canton, and they're all in one building. At least they used to be. I'm assuming they still. I don't know if COVID killed that or not. Do you have any idea, Christine?
I haven't heard. I don't know.
Yeah.
But I mean,
It
even
used to
like
be
the
all in one
national.
building.
Yeah. I mean, even the National Guard, I don't say it's like part-time military, but it is. I have a friend whose husband does that. If a lot of people maybe would be hesitant to just jump into the military, you have a pretty established life here, but so that might be an option. They might not pay for everything, but maybe they pay.
Yeah,
that's I don't know how that works. Yeah.
That's a good idea. Yeah. And unless you get called up, that's 1 weekend a month and 2 weekends or 2 weeks in the summer.
Yep.
Or used to be. Yeah.
Yep. That's
yeah. Look into that, D.
Okay. Definitely.
Yeah. Yeah. I mean, that's a lot of friggin' debt to take on. And I agree with you. It's different to spend, $500,000 to become a doctor than it is to spend $100,000 to be a social worker and make $25,000 a year. So I understand there's a cost benefit analysis that makes sense. But if there's another way to do it with no debt.
Definitely. I get what you're saying 100%.
Yeah, I mean, that gets you behind the wheel of the Lamborghini that much sooner.
Oh, man. You can't go wrong with that.
Anything else? Christine, you got anything?
No, I don't think so. I mean, we're emailing once, I don't know, every week and a half just to stay in touch, but no, he said everything was going great and confirmed it today.
Sounds
so
like it.
yeah.
Sounds like it. Yeah. All right. D, you made my day, buddy.
Oh, I'm glad.
Appreciate it. I'm going to go make Judge Greens now.
All right.
All right. Keep up the good work, guy.
Happy Thanksgiving.
Happy Thanksgiving.
Thanks.
Same to you.
See you guys later.
Right.
Bye-bye.